Hello, everyone. Welcome to this newsletter on democratizing funding for impact litigation. Today, I'm super excited to introduce our guest speaker, Susan Dunn from Harbour Litigation Funding, and actually asking her question on how can we leverage litigation funding to drive impact litigation at scale. She will share her perspective on what are different mechanisms around that to be able to create a more efficient legal framework to drive climate and social justice. Before diving in, I really wanted to introduce myself and what I do. So I'm the co-founder of The Impunity. We are a platform that connects impact claims with private capital, litigation funds, ad hoc funders, and we support law firms in assessing the viability of the cases. So without further waiting, I would like to introduce our guest speaker, a bit more about herself and her fund. Hello, Susan.
Hi, lovely to see you. Yes, so I'm a lawyer who ended up sort of getting into litigation funding by accident 22 years ago when it was a brand new thing. The only place that litigation funding was taking place at that time was in Australia. So that started around sort of 98, 99 in Australia, but didn't exist anywhere else in the world. And a chance encounter with somebody I had known on a tube train in 2002 led to us setting up the first funder in this jurisdiction, and the first funder outside of Australia, actually. And we started with just £1 million doing claims arising out of insolvencies where there was an evident need for funding. After developing that and developing the policy around funding in this jurisdiction, so making the policymakers aware of what it was, what it isn't, in 2007, I set up Harbour, which is now the world's largest private funder. We have about $1.8 billion across the funds that we use to fund litigation in what's been up to 17 different jurisdictions. And over that period of time, we have seen the growth of litigation funding to a really significant industry now, and also funding every single type of claimant and every single type of claim that we can think of. So its growth has been really interesting to watch and demonstrates the need for it. And that's not just by those with no money, but it's by those who have finite legal budgets and want the assistance of a funder to help them with the running of their claim, because they like that input that they get from a business whose only job day in and day out is to determine whether a piece of litigation is going to be successful, and if so, at what values. And the nice thing, and that's what we're going to come on to talk about today, is that has led to funding being used for what you describe as impact cases, because it turns out that you can also make money from impact cases. So it's a mutually compatible position to be in, to assist those who are trying to help remedy what you might call social injustices of various types, and at the same time make money to do so, because most people bringing these claims recognize that there is significant cost in doing so, and that they need the help of somebody like us to be able to bring their claims. And without that funding, they often wouldn't do, not least because these claims are usually individually quite small, but when gathered together as a group, make a meaningful amount of claim, and therefore the if you like, the might that comes from them acting as a group is what brings them their power to do so.
And I think your fund also has a real focus on those impact claims. For example, the class action that you have funded with 15,000 Indonesian farmers that have been impacted by an oil spill. And I think that's quite significant to see that growth and that sort of shift of litigation funds to be able to fund important claims. And I think maybe on that, my first question would really be to define the term ESG in the context of litigation funding, because today that term means everything and nothing at the same time. Mm-hmm. And I think it's super important to clarify that terms for the people that are going to watch that.
Yeah, and I think I get slightly frustrated with the use of ESG, because it means so many things to so many people. Now, some might say, well, it is simply about bringing environmental claims against oil companies or against governments for failing to honor their manifestos for achieving a net zero approach. But if you break down the words, which is environmental, social, and governance, well, every dispute contains at least one of those things, where you have had two parties have to litigate with one another. It is because one of the parties has failed in their responsibility to act properly in that particular relationship, which I would call the governance side of things. In the social things is everything, you know, we do a lot of this. It is in relation to where you've got workers who are not having their rights honored. So that might mean Uber drivers or Amazon drivers who are not being paid the minimum hourly wage. We've got 100,000 women whose equal pay claims we are funding. And that is very much a social situation where the companies in question have failed to honor their equal pay requirements. And the environmental is, yes, exactly, in our Montara claim, as we call it, it was 15,000 Indonesian seaweed farmers who the defendant had negligently maintained their oil rig. It exploded. There was a massive oil spill. That oil drifted from Australian waters to Indonesia, where it destroyed the seaweed crops of 15,000 seaweed farmers. That case took 8 years to conclude. So the defendant just dug in, and even after the claim had been won at trial, they still continue to try and make difficulties with post-trial applications. And I think it took a further 2 years post-trial before the claim finally settled. So 8 years, and I can't recall what the budget was, but it was approaching $20 million that had to be spent in order to call that particular company to account. And the very fact that they settled in the end meant that they had always known that what they had done was wrong. But without that litigation, they were never going to volunteer what I think amounted to in excess of $180 million being paid to those seaweed farmers. So without litigation funding, that simply would not have been able to happen.
And I think it's a perfect example of what impact litigation actually means and what are the mechanism behind that actually enable fruitful cases to actually come to fruition. And because I think for me, personally, I really believe that in a society that is driven by private markets and private capital in a way, it's super important to also know how we can leverage that capital as a force for good. And this is why I think the question about the tension between having a commercially viable entity that is trying to fund impact litigation and negative perception that some people can have on the fact that funders and lawyers are only there for money. What are your thoughts on that, and how do you approach it?
Yeah, and I think litigation is expensive. It's particularly expensive in this jurisdiction. And I think that we continue to need to find ways to conduct litigation more efficiently. It is without question far too expensive to get to the bottom of the issues that exist between the parties. So I accept that there is something that needs to change about the way that litigation is run. We find it frustrating. We see massive inefficiencies in the way that things are run, that there is still not sufficient use of technology to manage cases in a more cost-effective way. And the hourly rate is a disincentive to efficiency, because lawyers make money by charging by the hour. So if the less work they do, the less money they get paid. That kind of goes against human self-interest. But if cases were more cost effective, then actually what you could end up doing is doing more cases, because there are a lot of cases that we do we look at which we can't do because the costs of running them is not proportionate to the size of the claims. And so that's very frustrating from our point of view, because we're looking at a case saying, yes, we think this case will win, but unfortunately, given the cost to run this, and crucially, and this is a really important point, what we know about how the defendant is likely to behave. And it's a very common tactic for defendants to adopt a scorched earth approach to how they run litigation, and that they are not seeking early on to find a way to resolve these cases before all of those costs have been incurred. You don't need to incur those costs. And I think one of the things that I have as a frustration is, look, there's a lot of law firms who sign up to various pledges about diversity within their law firms, or that they're adhering to a better business conduct code of conduct approach, or that they are showing that they will behave ethically, and yet they string out litigation for years on end. And we've seen this in the post office case in this country, where in the inquiry emails have been revealed in which it was clearly stated that they should try to outspend the claimants in the hope that they ran out of money from their funders and that their claim had to discontinue. Now, that is deeply cynical behavior, and it cannot be reconciled with these law firms saying, hey, look, we're all shiny and we've got lovely ethics about how we do things, and yet we're prepared to act for these clients who we know are in the wrong, and yet we are trying to stretch these things out in order to see if we can make these claims go away. People say to us, oh, I guess you always want to go to trial. It's the opposite of what we want to do. What we want to do is to give the claimants the financial firing power to enable them to bring a claim in order to resolve that as soon as possible and be able to move on. That is the much preferred way. That we didn't want the Montara case to take 8 years. That was in nobody's interests to do so. So we really think that defense lawyers need to look to themselves and what they're doing and how they're advising their clients as to how they should conduct themselves, because that cynical approach, the scorched earth approach, really should have no place in the way that we're doing things. It is not to say that if you have legitimate defenses, you shouldn't put them forward. Absolutely. But this cynical use of kind of technical applications and trying to find ways to divide and rule the claimants and their funder is really, and we've seen it, I'm afraid, far too many times, that it needs to stop. It really does.
And I think that's a super important point, because it really comes back to the difference and a sort of tension between the notion of justice and how the legal system actually behaves itself.
Yes.
And I think this is why is also being able to bring those claims against corporate actors. It's all about how can we change behaviors, and it goes from the corporations, but also from what different legal actors are in the ecosystem that need to shift to be able to actually go back to the true notion of justice. But that would take some time to answer.
But you know what I'm starting to find encouraging? There's surveys, and I won't be able to quote who did them, but you're starting to see, when you look at surveys of younger lawyers and questioning them about, would you act for certain types of client? And increasingly, they're saying no to certain types of client that they wouldn't act for. And I think what you'll see is that they will also start to question behaviors within litigation. And these are the groups that are going to be in charge before we know it, right? And if they are demonstrating that they are wanting to adopt a more ethical approach to who they represent, if these people run out of people to represent them, which I know will take a long time, that's the thing that's going to make them again start questioning their behavior, rather than, unfortunately, money is not a good motivator to good behavior always, because people are there going, I've got to get my billable hours in. Look, I've got a client, he wants me to do this thing. And it's hard. I'm not pretending it's not difficult when you've got those pressures to bill your hours and make money for the firm. But I do think that then it's not mutually exclusive. You can behave ethically and make money at the same time. And that is what we're proving time and time again.
Yeah, no, totally, totally. And I think that would bring me to that next question on, in the context of litigation finance, how do you think it can support impact litigation at scale, which you answered before, but maybe what's your fund's approach to it and what specific criteria are you looking at before funding a claim?
Yes, well, I mean, look, it's interesting. When I look at the evolution of the business, is that you don't always have as clear a plan as it might then seem in hindsight. You might look like, oh, look, you made this plan to adopt these types of cases. The truth is that we have conversations all the time with law firms all over the world about the types of cases they're doing, and particularly when you see things like some causes of action arise in one country, and then you say, well, should those be happening here, and can we find a way to get them off the ground, and what are the differences between the different jurisdictions? But when we started doing things like Montara, nobody sort of said, oh, well done for doing that or whatever. Everybody was still focusing on the legal aspects of the case and whether we could prove that the oil had caused the seaweed to die, and everybody had said, well, gosh, that's just going to be very difficult. But in a very simplistic way, we don't look at these cases in any way differently than we look at every single case that we assess. But it is true to say there is a much higher level of happiness when you get success in a case like a Montara than in a regular old commercial dispute between two parties. It's just, you see that. I saw that within our organization, that people were so much more excited about having achieved that outcome for those seaweed farmers. And all that does then is it's a kind of virtuous circle of, it continues to encourage people within our organization to think more broadly about, well, I've learned about these types of cases. Gosh, I wonder if we at Harbour could make this work from a funding point of view. And you just start to see that engendered in the corporate DNA as to people having conversations which they might have thought they couldn't have. It's almost like doing those sorts of cases gives people permission to think more ambitiously about the types of impact cases that they might be taking on. I mean, to be clear also, there are certain types of cases where you do look at them and you think, well, that appears on the face of it to be a good thing to do. But when you look at the values of the cases and the costs that the lawyers are going to charge, it's just an exercise in legal fees. And actually, we will then walk away from those sorts of things where the legal fees are far larger than the claim values. Then that's not the right thing to be getting involved in. There has to be better ways of making those sorts of cases work. Otherwise, it does end up looking like a cynical activity in maximizing lawyers' fees.
And if I was a law firm listening to this recording and video, and I would want to bring you a lawsuit that is focused on the impact sector and maybe a class action, what sort of key criteria my claim would need to meet in order to be fundable by your fund or by another litigation fund?
Sure. Well, and this is the thing. 22 years I've been doing this, and you know what? These factors have never changed. And they've never changed because they are always the right factors to take a look at. So the number one question is always, who is the defendant? And have they got the ability to pay the amount that we're claiming? And where are their funds located? Because without that, the rest of the case is absolutely irrelevant. And too often still, people come to us not having the answer to how the defendant is going to pay the amount of claims. Really important. The second thing is, what is the value of this claim? And what we tend to find is that people overestimate the values of claims. Now, we understand that you might plead a number of heads of claims, which notionally looks like a higher value. But what we want to know is, what is the realistic minimum value of the claim? So that's really, really important. The third thing, and this is where people get it wrong in the other direction, so people massively underestimate, is what is the budget going to be to run this case? And too often we see lawyers underselling how much money they're going to need to run the case. And too often I hear people saying, yeah, but if I told you what it was really going to cost, you wouldn't hire me. And I'm like, well, that's not the way to go about it, because the worst of all worlds for a funder is to get halfway through a case and then to be told, oh, actually, the budget needs to double. Claim value hasn't increased. And we're stuck with a kind of half-built house that we now need to put more money into. And had we known what it was going to cost in the first place, then we probably wouldn't have funded it, because the economics don't work. So lawyers continue to have to get better at this than they are. You know, it's one thing, it's all very well to say, I'm a really good litigator, but I'm really rubbish at budgeting. If you're really rubbish at budgeting, you're not a really good litigator, because you might achieve outcomes at costs that were prohibitive. So what's the point of that if the claimant is left with nothing to recover? So we take a look at that, and then when we, and crucially, obviously, where is the jurisdiction for this claim? How predictable are those outcomes there? And what is the likely duration for that claim? I mean, with Montara, we never contemplated that would take 8 years, but sadly it did. And that is not where anybody wants to be. We want things to be done quickly and efficiently. So it's when we've looked at those economic and duration, we then dig into what are the legal strengths and weaknesses of the case, so that we can take a look at those and see how somebody's presenting, that we interrogate that. We're all lawyers at Harbour who have got a lot of experience, so we've got a good ability to interrogate what we're being told. And clearly what we're looking for is cases where we think that we have the better claim. People say, oh, do you have a set percentage or this or that? We don't, because you know, my 70 might be your 50. So that's very subjective. What we want to see is a clear statement of the facts, what the applicable law is, and then analysis of where you think the strengths and weaknesses are in a case. I always say to people, put yourself in our shoes. What would you want to know if you're being asked to spend, you typically several £million on the budgets for these cases?
Yeah, absolutely. And the thing is, for example, us, we receive a lot of claims from more global south countries, so Brazil or Southeast Asia. And what's the approach of your fund towards that? Because we try to focus on parent company liability, but what we're seeing right now in the market more and more is that they're also trying to bring those cases to national courts. How do you sort of manage that? Or are you more looking for cases that can be litigated in more, I would say, solid jurisdiction, or maybe the UA, the UK or Australia?
Yeah, and look, during lockdown, we kind of reviewed our own expertise to say, well, what is it that we're good at? What is it that we're not really very good at? And you know, what you're always trying to do, you kind of look, as a funder, you expect to lose some cases, even though you're only taking on what you think are good cases. Cases lose, and they lose for a whole variety of reasons. If you can understand why they've lost and what you can therefore avoid in the future, then you don't mind doing something again, because you go, well, in the future I'll do that case, but I'll avoid it if it's got this involved. With too many types of cases, we found that nobody could really explain to us why we had lost. So, for example, bilateral investment treaty cases against countries, we've consistently lost those despite them being run by the best lawyers that in that area, and they couldn't explain to us why we were losing. So we said, look, we have to just stop. Certain jurisdictions, we just could not make any progress. We have funded some Brazilian arbitrations, but not any Brazilian litigation. And you know, part of the challenge is that we don't have experience in these jurisdictions, and you know when you know that you do well in certain jurisdictions, we're here to look after our investors' money, and therefore we need to stick with what we're good at. So we just don't have the experience of running cases in Thailand or Vietnam or even the Middle East. We do have experience in Hong Kong. We do have experience in Australia. So if you don't have that experience, then you're really starting from ground zero. And why do that if you can fund cases in jurisdictions where you have a lot of experience and therefore hopefully a better basis on which to predict the outcomes?
Absolutely. And I think my last question there is, what trends are emerging in the field of impact litigation? And I would say specifically in the climate litigation space, because it's a topic that everyone is talking about, but as you might know, it's quite complicated to fund those claims at this stage because they are super new. And how do you think maybe litigation funding will need to evolve accordingly to be able to then potentially fund those claims?
Yeah, well, look, I mean, we've seen, and there are law firms who are trying to have historically tried to bring, and I know we mean different things by climate and environmental, but if you look at firms like Lee Day, they have brought claims against Shell in relation to oil spills in Nigeria and trying to help the communities that are impacted by that. We've got the Brazilian dam case, which is taking place in this country, even though the events took place in Brazil because of that parent company liability piece. But in each of those cases, there is a relatively clear financial outcome that comes with those cases. With what we've seen, so the firm called Palas did a pro bono application for, and I've forgotten their name, but they were seeking to challenge, I feel like it was the Dutch government, about their approach to their manifesto. In quite a lot of these cases where it is simply declaratory relief that the claimants are seeking, i.e. to get somebody to honor a promise where there's no actual financial outcome, I think that's going to remain a struggle for funders to get involved in on any particular level. You've then separately got things like countries like the Maldives, which sit at sea level and whose sea levels are rising to kind of destroy certain of their communities, where they are seeking to assert against oil companies a kind of fractional share of the responsibility for the damage that is caused by the climate change, which they would say comes from their fossil fuel burning activities. Again, those are right at the kind of cutting edge of litigation with no precedent about how one allocates the responsibility for these things. And I guess for now, I think that those are still very difficult cases to bring. It kind of needs some momentum to come from somewhere to hold these people to account, to give that momentum that judges in other countries or other forums then feel that they've got some kind of precedent for saying, you know what, I am going to make X oil company X% liable for the destruction that's happened here. But it's still pretty cutting edge. So I think we've still got a little while to go before we see any of those in any meaningful way, I'm afraid.
And I think this is why it's also interesting, because I've been talking with impact funds that were, basically speaking about constructing portfolio of injunctive relief claims to then be able to sort of yield damages claims out of that in the climate litigation sphere. But the main question was, how long is it going to take? And I think that's a question that we're not yet able to answer at this stage.
Yeah.
And last but not least is, what final advice would you give those litigation groups that we have in our network? So it might be NGOs, but also small and medium law firms, to be able to access funding for the litigation.
Yeah, and look, I described what's required for a piece of litigation. Put yourself in our shoes. We don't have a magic wand to make bad cases good. So if you think a case is a good one, what I always urge people to do, though, is to be in contact with us early. What we don't want is people wasting huge amounts of time preparing a case which has, from a funding point of view, a fundamental flaw in it. So look, we don't need to know the names of the parties. We just need to know the headline facts of a case in order to have a really early conversation which can help guide the law firm then into what information they need to gather in order to secure a funding offer. So I can't emphasize enough that need for early engagement. I think people sometimes feel that they're almost embarrassed if they don't have much information to talk about. We will not feel embarrassed for you at all. We'll be super happy that you came and spoke to us to say, look, I've got this thing, I think it looks like this, what do you think? We are really, really happy to have those conversations. So please don't spend tens of hours on preparing some beautifully presented document, which we just turn to page 5 and go, oh dear, that bit's never going to work, because that was just a waste of your time, right?
Amazing.
Very much.
That's
Thank you.